He sued for $340,000. The verdict changed everything. A landlord walked into court asking for $340,000. He walked out with something worth far more and far less than he ever imagined. For 11 years, the landlord had built what he called his system. Not a building, not a portfolio, a methodology. He managed 14 rental properties across a mid-sized Midwestern city using a proprietary tenant screening process he'd spent years refining. A 47-point evaluation framework he called the Residential Compatibility Index. It weighted everything from rent-to-income ratios to references from prior neighbors, not just landlords. He claimed it reduced his vacancy rate to under 2% annually and kept eviction proceedings off his record entirely. He'd even begun quietly licensing it to 2 private investors. It wasn't just a spreadsheet, it was, by any reasonable measure, his life's work in document form. In March of a recent spring, he hired a regional property management company to handle day-to-day operations for 6 of his units, while he recovered from a cardiac procedure. The agreement was straightforward. The company would collect rent, coordinate maintenance, and handle tenant communications. Nothing more. He handed over operational access to his systems, including the full Residential Compatibility Index, under what he believed was an implied confidentiality arrangement. No formal NDA was signed. That detail would matter enormously. By August of the same year, the landlord noticed something troubling. A former tenant mentioned that the property management company had recently launched a new service, a proprietary tenant placement package, marketed to other landlords in the region. Curious, he requested their promotional materials. What he found stopped him cold. The framework being advertised, down to the categorical structure, the neighbor reference weighting, even the specific language around what they called residential harmony indicators, was his system, rebranded with a new name and a company logo. He terminated the management agreement immediately and filed suit for $340,000, representing lost licensing revenue, reputational damages, and the projected value of the intellectual property as a standalone product. In court, the landlord's attorney laid out the case methodically. Side-by-side comparisons of the original index documents, time-stamped, version-controlled, and stored in a cloud system predating the management agreement by 6 years, against the company's marketing materials were entered into evidence. A forensic document analyst testified that 31 of the 47 evaluative criteria appeared verbatim or near verbatim in the company's materials. The landlord himself took the stand quietly, without theater, and described the years of iteration. He didn't perform grief. He simply said, "I trusted them with the keys to my house, and they copied the locks." The property management company's defense was equally composed. Their attorney argued that no intellectual property protections had ever been formally registered. The Residential Compatibility Index had not been copyrighted. No trade secret designation existed. The company acknowledged using the landlord's framework internally during the management period. They called it operational familiarization. But they contended that general business methodologies, unless formally protected, exist in the public domain of professional knowledge. Their lead property manager testified that similar multi-factor screening processes were widely used across the industry, and that any resemblance to the landlord's specific framework was a matter of parallel professional evolution, not theft. Then the company's own internal communications were subpoenaed. An email chain from the month following the management agreement, just 6 weeks after receiving the landlord's documents, showed the company's director writing to 2 senior staff members. "This screening model is genuinely impressive. Let's adapt it for our placement package before the fall rollout." A second email, 2 weeks later, asked a junior analyst to restructure the categories enough that it reads as our own development. The phrase, "reads as our own development," hung in the courtroom like smoke. The judge, a 23-year veteran of civil litigation, did not rule the way either side anticipated. She found that the landlord's framework did not meet the legal threshold for trade secret protection, as it had been shared without confidentiality agreement and lacked formal registration. On those grounds, the $340,000 claim was denied. However, she ruled that the internal emails constituted documented evidence of intentional misappropriation and bad faith conduct. Under the doctrine of unjust enrichment, she ordered the property management company to disgorge all revenues earned through their tenant placement package since its August launch, a figure calculated at $47,200. payable to the landlord. She further issued a permanent injunction barring the company from using or marketing any framework derivative of the Residential Compatibility Index. The landlord did not celebrate on the courthouse steps. He accepted the check. He filed for copyright registration the following week. The property management company quietly discontinued their placement package within 30 days of the ruling. No appeal was filed. The two investors who had been licensing the landlord's original system renewed their agreements at a rate 40% higher than before, citing, with some irony, the newfound notoriety of the framework. Justice arrived that day, but it arrived partial and procedural, dressed in the fine print the landlord had once been too trusting to write, which raises the question worth sitting with. If you built something valuable through years of honest work and someone took it because you forgot to lock the legal door, who is actually responsible for what happened next?